Convention Number 100, concerning equal remuneration for men and women workers for work of equal value, done at Geneva on the 29th of June 1951, entry into force, the 23rd of May 1953. Preamble. The General Conference of the International Labour Organization, having been convened at Geneva by the governing body of the International Labour Office, and having met in its 34th session on the 6th of June 1951, and having decided upon the adoption of certain proposals with regard to the principle of equal remuneration for men and women workers for work of equal value, which is the 7th item on the agenda of the session, and having determined that these proposals shall take the form of an international convention, adopts this 29th day of June of the year 1951 the following convention, which may be cited as the Equal Remuneration Convention, 1951, for the purpose of this convention. Article 1, a. The term remuneration includes the ordinary, basic or minimum wage or salary and any additional emoluments whatsoever payable directly or indirectly, whether in cash or in kind, by the employer to the worker and arising out of the worker's employment. b. The term equal remuneration for men and women workers for work of equal value refers to rates of remuneration established without discrimination based on sex. Article 2, 1. Each member shall, by means appropriate to the methods in operation for determining rates of remuneration, promote and, insofar as is consistent with such methods, ensure the application to all workers of the principle of equal remuneration for men and women workers for work of equal value. 2. This principle may be applied by means of a. National laws or regulations, b. Legally established or recognized machinery for wage determination, c. Collective agreements between employers and workers, or d. A combination of these various means. Article 3, 1. Where such action will assist in giving effect to the provisions of this convention, measures shall be taken to promote objective appraisal of jobs on the basis of the work to be performed. 2. The methods to be followed in this appraisal may be decided upon by the authorities responsible for the determination of rates of remuneration, or, where such rates are determined by collective agreements, by the parties thereto. 3. Differential rates between workers which correspond, without regard to sex, to differences, as determined by such objective appraisal, in the work to be performed shall not be considered as being contrary to the principle of equal remuneration for men and women workers for work of equal value. Article 4. Each member shall cooperate as appropriate with the employers and workers' organizations concerned for the purpose of giving effect to the provisions of this convention. Article 5. The formal ratifications of this convention shall be communicated to the Director General of the International Labour Office for registration. Article 6, 1. This convention shall be binding only upon those members of the International Labour Organization whose ratifications have been registered with the Director General. 2. It shall come into force 12 months after the date on which the ratifications of 2 members have been registered with the Director General. 3. Thereafter, this convention shall come into force for any member 12 months after the date on which its ratification has been registered. Article 7, 1. Declarations communicated to the Director General of the International Labour Office in accordance with paragraph 2 of Article 35 of the Constitution of the International Labour Organization shall indicate, a. the territories in respect of which the member concerned undertakes that the provisions of the Convention shall be applied without modification, b. the territories in respect of which it undertakes that the provisions of the Convention shall be applied subject to modifications, together with details of the said modifications, c. the territories in respect of which the Convention is inapplicable and in such cases the grounds on which it is inapplicable, d. the territories in respect of which it reserves its decision pending further consideration of the position. 2. The undertakings referred to in sub-paragraphs A and B of paragraph 1 of this article shall be deemed to be an integral part of the ratification and shall have the force of ratification. 3. Any member may at any time by a subsequent declaration cancel in whole or in part any reservation made in its original declaration in virtue of subparagraph B, C, or D, of paragraph 1 of this article. 4. Any member may, at any time at which the Convention is subject to denunciation in accordance with the provisions of Article 9, communicate to the Director General a declaration modifying in any other respect the terms of any former declaration and stating the present position in respect of such territories as it may specify. Article 8, 1. Declarations communicated to the Director General of the International Labour Office in accordance with paragraph 4 or 5 of Article 35 of the Constitution of the International Labour Organization shall indicate whether the provisions of the Convention will be applied in the territory concerned without modification or subject to modifications. When the declaration indicates that the provisions of the Convention will be applied subject to modifications, it shall give details of the said modifications. 2. The members or international authority concerned may at any time by a subsequent declaration renounce in whole or in part the right to have recourse to any modification indicated in any former declaration. 3. The members or international authority concerned may, at any time at which this convention is subject to denunciation in accordance with the provisions of Article 9, communicate to the Director General a declaration modifying in any other respect the terms of any former declaration and stating the present position in respect of the application of the Convention. Article 9, 1. A member which has ratified this Convention may denounce it after the expiration of 10 years from the date on which the Convention first comes into force, by an act communicated to the Director General of the International Labour Office for registration. Such denunciation shall not take effect until 1 year after the date on which it is registered. 2. Each member which has ratified this convention and which does not, within the year following the expiration of the period of 10 years mentioned in the preceding paragraph, exercise the right of denunciation provided for in this article, will be bound for another period of 10 years and, thereafter, may denounce this convention at the expiration of each period of 10 years under the terms provided for in this article. Article 10, 1. The Director General of the International Labour Office shall notify all members of the International Labour Organization of the registration of all ratifications, declarations and denunciations communicated to him by the members of the organization. 2. When notifying the members of the organization of the registration of the second ratification communicated to him, the Director General shall draw the attention of the members of the organization to the date upon which the convention will come into force. Article 11. The Director General of the International Labour Office shall communicate to the Secretary General of the United Nations for registration in accordance with Article 102 of the Charter of the United Nations full particulars of all ratifications, declarations and acts of denunciation registered by him in accordance with the provisions of the preceding articles. Article 12. At such times as may consider necessary, the governing body of the International Labour Office shall present to the General Conference a report on the working of this convention and shall examine the desirability of placing on the agenda of the conference the question of its revision in whole or in part. Article 13, 1. Should the conference adopt a new convention revising this convention in whole or in part, then, unless the new convention otherwise provides, a. The ratification by a member of the new revising convention shall ipso jure involve the immediate denunciation of this convention, notwithstanding the provisions of Article 9 above, if and when the new revising convention shall have come into force. b. As from the date when the new revising convention comes into force, this convention shall cease to be open to ratification by the members. 2. This convention shall in any case remain in force in its actual form and content for those members which have ratified it but have not ratified their revising convention. Article 14. The English and French versions of the text of this convention are equally authoritative.